Good evening, everyone. Thank you very, very much for attending. This is the residual losses state liability claim that we are launching, and it's a fairly brief presentation. Let us begin with your unrecovered losses. The starting point is that you have mitigated your losses by settling or you are about to settle with all your opponents. So if you have not settled yet and you're about to settle, that's fine. If you have not made any steps, you just have not tried to settle with your opponents, you need to do so before you can talk about residual losses, because you obviously need to have attempted to at least mitigate your losses before you can claim anything further. Why have we been left with unrecovered losses? Well, basically, you were faced with gross negative equity. What we refer to as gross negative equity is the difference between the value of the property and the amount you laid out. So that the gross negative equity would be if you have a loan with the bank, if you paid the deposit, if you made repayments, all of that together, take away the value of the property, and that is your gross negative equity. Your net negative equity, on the other hand, is how much you owe to the bank minus the value of the property. And most of you were facing, apart from gross negative equity, you were facing also net negative equity, and you could not sell and redeem. You would have been left with a balance to pay. Now, we settled with the bank, but then you have the remaining losses, monies that you paid to developers, money that you paid to lawyers. All of that is what remains to be recovered. We concluded that the court may not agree that the parties you are suing were responsible for all your losses. That is a problem, particularly when you have multiple defendants, and where you have settled with the main one. The bank has taken the main knock out of your losses. Even if you won, you would normally only receive 60 to 70% of your costs. So there was a balancing act, at least for this group. I don't know about other groups to take into account, that we needed to take into account the risks of further litigation, the likelihood of winning, the likelihood of losing, the likelihood of being left with unrecovered losses, and also the risk that the court would say, well, yes, okay, they failed to issue title deeds, but that wasn't their fault. That was down to effectively the land register in Cyprus, and they've got a good reason why they did not meet their commitments. So what are your unrecovered losses? If any of you have looked at the online form we provided, it goes through and asks you various questions where it asks you for figures. Once these figures are provided online, we will produce a statement of losses, which looks like this. And as you can see, the statement provides the amounts you've given us on the top section, less the amounts you've given us for the bottom section, and it leaves a balance. In this case, this client surrendered the property to the bank, was left with unrecovered losses of 102,000, allocates own occupation and no own occupation benefit or rental income 4.5, leaving still losses to be claimed from the Republic of Cyprus of 98,136. Now, why are we claiming from the Republic of Cyprus? What exactly, when is the state liable? for such losses. We believe that you were victims of mis-selling. That is the starting point. We believe that the Republic of Cyprus was complicit in that mis-selling. We believe that the Republic of Cyprus benefited from this mis-selling, and that it had the opportunity to stop the mis-selling, but it didn't. It had the opportunity to remedy the damage, and it didn't. It failed to comply and enforce EU law, and it failed to provide access to justice. So this is the main thinking behind this claim, that yes, there were civil parties responsible for what happened, but they operated within an environment which has been created and allowed to happen by the Republic of Cyprus. And a lot of them would say, well, I was only doing what was within the parameters. Now, the problem with state liability is that you would need to obviously sue in that country, make a claim within their own courts. So if that was to happen, we would have a problem. That will explain why. And that will explain why we're looking at the European Court of Human Rights, to go directly to the European Court of Human Rights. The reason is that proceedings for state liability in Cyprus need to be commenced at the district court. There are no class actions facilities in Cyprus, so each one of you would need to issue it individually. The likelihood of a district court in Cyprus finding in favor of a claimant in cases of state liability is almost nil. The case, therefore, is likely to stretch to the Supreme Court and possibly the Court of Justice of the European Union. Currently, district courts in Cyprus are dealing with 2013 cases involving the Supreme Court in an appeal and a possible referral to the Court of Justice of the European Union would stretch it much further. We would be looking at over 10 years before we get anywhere. Access to justice is a fundamental human right which the ECHR should uphold. And basically, as we shall see in the next slide, justice delayed is justice denied. Now, the ECHR will look at cases on merit and on exhaustion of local remedies. So, does your case have merit, or is it nonsense? And have you gone through the local remedies? If you haven't, you've got to go through them. On merit, the Republic of Cyprus should have safeguarded your rights to property. This is a fundamental human right. They should have safeguarded your rights to property. You thought you were buying something with absolute title, and you ended up with something in somebody else's land. The second point is that the Republic of Cyprus should have safeguarded your right to justice, that you should have been able to get a remedy for the problem that was created. The Republic of Cyprus, therefore, should be liable to pay damages. Again, very simple logic, very clear steps. With regard to exhaustion of local remedies, justice delayed is justice denied. The European Court of Human Rights recognizes that anything over 3.5 years is unreasonable. And here we're talking about anything upwards of 7 years, and more likely 10 and more. We also aim to maximize numbers. It is unreasonable for the Republic of Cyprus to expect each one of you to file individually when the cause is common. Nevertheless, that is the only remedy available. And again, we think that this is a denial of access to justice. It is unreasonable for the Republic of Cyprus to expect 1,000 cases to wait in the 7 to 10 year queue for a court to hear the same facts and dismiss them because Cyprus law does not recognize the basis of such a claim. The conclusion, therefore, is that there are no local remedies available, which is what we will be trying to establish in the first instance. What are the time limits? The time limit to refer something to the European Court is 6 months, and that is pretty strict. But then it's a matter of from what date. The date is basically from the date local remedies have been exhausted. So yes, there were local remedies available. You went through them. You went to the Court of Appeal. A decision was made by the Court of Appeal to dismiss your case. You now have 6 months to refer it to the European Court of Human Rights. But in the case where there are no local remedies are available, you are then looking at the crystallization of your losses. And crystallization effectively means not only settling with the bank, but getting information about all your losses, and the awareness of the fact that there are no local remedies available. So when are you becoming aware of this fact is round about now, and this is why we've got a very short window to try to get a claim to the Attorney General of Cyprus. If he accepts the claim and sits down to negotiate, that's fair enough. If not, then we will need to apply to the European Court of Human Rights to have our case heard. The first hurdle to overcome would then be for them to admit the case on their admission criteria. We will be asking the Attorney General to acknowledge absence of an effective remedy or to compensate. So that is the first step that we're going to take. So what are the next steps? The first one is to register. If you want to participate in this claim, you need to fill in the online form. Spread the word. The larger the group, the more seriously the claim will be treated. If 10 or 20 or 50 people turn up and say, we have been treated unjustly, the European Court of Justice, or for that matter, the Attorney General, may say, forget it, I can't be bothered. But if 1,000 people turn up, then they would have to think twice before we're dismissing it outright. So we think that numbers will matter, and we are very much relying on you to spread the word. If your registration is approved, you need to agree to retain us, and then we will go through the terms of the retainer in the Q&A session. So this is the end of the presentation. I will go through the questions. Before you raise any questions, please wait until I've gone through the frequently asked questions, and only if I have not answered your query, then by all means raise it on chat, and I will try to respond. So, frequently asked questions, residual losses. Why have we been left with residual losses? Because we reached the maximum the banks were willing to agree, and we could not be certain that we could get a better result through the courts. Why could we not claim from the other parties? It has been attempted by other claimants outside our group. We're not confident that the settlement we reached with the banks would leave sufficient quantum to claim. And I think that monitoring a case which is going through the courts now, this is the conclusion we're reaching, was that ours was the right conclusion and the right strategy. But of course, time will show. Overall, we achieved the write-off of all the interest and around 40% of the capital advanced, which would eat into any claim against the developer. This is one of the problems, that quantum of the cases, not so much, did developers misrepresent? Did they do this? Did they do that? It's not that. It's not just liability. It's also what is it that you're claiming. And since the bank has taken by far the biggest knock out of all this whole loss, then what would be left to argue that the developer should cover. Would the developer be able to cover it? Or a lot of them have already disappeared or gone into liquidation. And would a court looking at the quantum say, well, yes, the developer is responsible for all your other losses, particularly if the developer is pleading to say, well, this is just the way things work in Cyprus. We achieved substantial write-downs even for clients who kept their property. So in terms of the settlement, we're pretty confident that we did the right thing. Despite the complicity of the parties, the lack of government control and the chaotic situation that the government allowed to develop gave defendants a further defense. It is right that we should turn on the Republic of Cyprus. What we have heard time and again is, yes, I was late delivering the title deeds, but that's not my fault. What happened in the meantime, it's not down to me. This is the way things work in Cyprus. We have also heard that from lawyers who say, well, this is the level of advice that was available at the time. A waiver was not asked for from the previous mortgagee, but again, everybody knows that this is off-plan sales are for properties within somebody else's land, or so what's the problem? They see that as being the norm. And then a large percentage of legal costs cannot be recovered. That is always a problem, that when you start spending on litigation, you need to make sure that even if you win, you will not recover all your costs. And if you're not recovering all your costs, how much of unrecovered will you be out of pocket for? The second question is about your eligibility to join this action group. The first question a lot of people ask is, what if I have not yet settled? And the answer is, you can still register, but where you do not know the settlement figure, provide an estimate. There are questions at the end of the questionnaire which allow you to identify which figures are estimates. So we will be taking that into account, and hopefully by the time the claim is progressed, you would have settled. What if you have not done anything at all to settle? In other words, not represented by a firm of solicitors, you haven't approached the bank, you just left it. What do I do next? Well, the first step is to mitigate your losses as soon as possible. What if I'm not an existing client? Yes, you can register. Everyone is welcome. What if I have no Cyprus bank loan? Again, you can still register, enter amounts you paid to the vendor, and ignore questions about amounts paid to the bank. So that's fairly straightforward. Regarding new clients, people who have not been with us and they have not taken any steps to settle, simple answer is that we can help. Again, the form allows you to say, I have not settled. And if you want to proceed, then we can take over the case for you and settle it before we determine your residual losses and we include you in the claim. Why should I bother? The bank has not bothered me. It is almost impossible that the bank will write off the loan without at least recovering the property. If you have not heard from them, you will. Just think about it logically. They may have been for many years not been in touch with you. That's because they are far too busy collecting from, if you like, the low-lying fruit. But if you have disappeared and you're off their radar, at some point they will need to trace you, because they're not going to write off the loan without at least recovering the property and at least trying to enforce whatever debt is left on your assets wherever they can find you. So it's not smart to just let it run. Why should I instruct you and not another firm? I think we would invite you to speak to an existing client who has settled through us. Pick any client at random and ask. Check and compare costs and what they cover, and compare our record. What is our record? Well, we are the largest group, almost 1,500 clients that served by George Kunis in the past few years. Over 100 million euros written off by banks on our cases, and we believe that we've got the most effective, cost-effective package. Is it possible that my registration will be rejected? So you may want to register and participate in this, but we may say no. It's unlikely, but it is possible. The possible reasons for rejection are your claim may be out of scope. We are looking on this claim for people who purchased property in the decade between 2000 and 2010. If you present us with a different set of circumstances, it may be outside the scope of this particular action. But we would always look at it and say, consider what else you could do if you've lost money. There may be a conflict of interest. If you owe us money and you have not settled, we may become adversaries in court, and that would form a conflict, and therefore we would not be able to take you on in any event. And there are certain clients whose participation would be unwelcome in any event. We really want clients who are supportive and they're not disruptive. Where we've had the experience of disruption, we don't want to know, and I think this is our right to say no. It is also possible for the registration form to be rejected, not as opposed to the client, but the actual form for some reason cannot be processed. The main reason would be insufficient information, and let's look at some of the typical pitfalls. What sort of errors will reject the form? Well, primarily the value of the property. I need to fix this. Can you just excuse me 1 second, because I made a mistake here. I should have let me begin again. My sincere apologies. Okay. The value of the property. As you can see, this particular form, value of the property on settlement says not known. So it is important to have this information. Not in this instance, by the way. I don't know why we use this form, because it wouldn't affect us. We've got other reasons here. Let me just see. Yeah, the value of the property is not known. That on this form, because it says property surrendered, it wouldn't actually affect it. I don't know why I included it here. But if you're missing the value of the property, if you, at least clients of this firm, are getting regular client account statements, the cash, and at the back of the cash, you will find all the information you need about your property, the current balances we have from the bank, your contributions, the value of the property that's been agreed, etc., etc. All that information is there, so there is no really good reason to miss that out. Also missing information. Here, this is the form that I should have used in the previous slide, and I apologize for this. You can see that although we've got the value of the property here, what we don't have is an amount for the bank redemption. Now, the reason why this client has not put in the amount is because it says not yet resolved. So a settlement is pending, but the client should know roughly what the settlement will be. Without putting a figure in, you can see that the amount of claim turns out to be negative. It's only when you put a figure in here that the actual residual losses will appear. It is going to be an estimate, a rough estimate, and you would be indicating that further down the form to say this is an estimate because I have not yet settled. So we're trying to facilitate. We're not saying to you wait, because if you wait until you get all the figures in, it may be months and months and months, by which time you may miss the boat. So it's important to register, and then we can pick up any estimates and crystallize on them later on. These are the most common form filling errors. What are the basic terms of the retainer, which is what we mentioned before? Here there are two options. The first option is to allow us to do everything without expert counsel. Now, obviously, having got expert counsel, people who specialize in European Court of Human Rights proceedings and pleadings and what have you, but obviously that costs money. So we say that if the group decides that we do not want to spend any money at all, it can be done on a no-win, no-fee basis. So we would be running the show. We would prepare the claim, we would submit it to the Attorney General. If the Attorney General accepts it and sits down to negotiate, that's fine. Then whatever we manage to settle for, we would have a percentage of that as our remuneration. So it's this would be the one way, which would be without expert counsel, just us dealing with everything on a no-win, no-fee basis. The alternative is that the group, the majority of the group, may decide, well, yes, it's going to cost a few £100 to have expert representation, well worth it. If that is decided, then that option will be offered to you. If the group decides that that's fair enough, then that cost would need to be covered. If you want to continue, but you would have the option not to continue. But I would wait until we are somewhere with this. If the claim is rejected by the Attorney General, then we can look at costs, and we can decide then whether we are just continuing without any cost on a no-win, no-fee basis, or whether some cost is going to be incurred to get expert advice from human rights specialists. So for the preparation of the application to the European Court of Human Rights, it can be done on a no-win, no-fee basis by us. Preparation of pleadings can be done by us on a no-win, no-fee basis, and written submissions, oral submissions, can also be done by us on a no-win fee basis. The alternative, as I say, would be to employ expert counsel, and we would let you know, and then you can decide by majority. The success fee is 20% plus VAT of amounts recovered. So it's fairly simple damages-based retainer. It's going to have provision for disbursements if agreed by the majority of the group, with the option for you to opt out if you don't agree. Can I decide to pull out without incurring any cost? Yes, if the majority of the group agree to incur and share disbursements and you do not agree to participate, then yes, you can just pull out. Or no, if no disbursements participation is agreed by the majority, or if you agree to share disbursements and you later change your mind. So the principle is pretty simple and fair. You have to allow us to earn money for our work if we succeed, and we have to allow you, and we need to have your consent to proceed. But where you have given consent and you have caused us to incur costs on your behalf, spend time on your case, etc., 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 it is only fair that we are compensated. But you are in full control. So in terms of what cost would you incur if you pulled out, if you do not agree to participate in disbursements, and the majority do, so it is a matter of the majority wanting to proceed to incur expenses, you can pull out at zero cost. But if the majority say no, we're just going to carry on a no-win, no-fee basis, then you can't pull out because we have already done work for you. If you decide to pull out up to 80% of the way, the cost that you will incur is time spent at full commercial rates plus disbursements. There may also be practical and cost implications of pulling out. So late that will be so late, so that will be advised to you at the time, depending on the circumstances we face. So the key here is that we would advise you every step of the way. We need your consent to get to the next step. But if you do give your consent, you need to allow us to finish the job so we can earn our money. If you don't, then yes, you can pull out, but then you've got to pay for the time we spent on your case, and also depending on when you decide to pull out. So up to 80% of the way through, it's going to be on our commercial rates. If it's beyond the 80% and but before there is the final hearing, then it would be twice full commercial rates and disbursements. If it's sort of once the hearing commences, then it would be more or less success fee. If a success fee is due. If we lose, then again there wouldn't be anything payable. So the preliminary application to the ECHR is deemed to be 80% of the way. So if you pull out before then, after we've done work, then you may be liable for that. And that is the basic. These would be the basic terms of the retainer. Again, the retainer will be sent to you. You'll have the opportunity to study it. So you register, then we offer you a retainer, then you decide whether you want to join or not. What level of service can I expect? You must allow us to get on with our job without taking up our time. This means you must wait for group updates and not ask for individual updates. We've had this problem in the past, which is taking an inordinate amount of time. You must respond to our communications without the need to chase you. You must agree to pay for additional services, which may include having to chase you. So if you are that type of client that needs chasing, is not responding, is not providing the information, needs hand-holding all the time, frankly, we don't want you as a client unless you're paying on a time spent basis. For group actions, really people need to fall in and need to be responsive. Otherwise, it doesn't work. It's not fair on the firm. It's not fair on others either, waiting for someone to complete a form or waiting for someone to provide a bit of information. So it's got to be fairly regimented if we're going to proceed with this. We have learned some hard lessons from very few but very determined clients bent on getting their way. So this time we're going to be extremely careful that we don't get into this situation again. How do I publicize the action? Well, the main and most convincing way is word of mouth. People that you know, let them know that this is happening and that they need to act now, otherwise they miss the boat. Social media, and write to politicians and the press. A press release has been circulated, which you can publicize widely to people that you know, people in your development or anyone else. Why can't I just wait to see what happens? There is a 6-month strict time limit set by ECHR. If you miss it, you will be time barred. the chances of success are far greater if the Republic of Cyprus and the ECHR are faced with vast numbers. So again, help the group so that the group can help you. Join now so that we have this strength in numbers. Please join now and encourage others to do the same.